and reforms aimed at enhancing governance and regulatory structures in the energy and infrastructure sector and creating enabling environments for increased private capital into these sectors. She previously worked with the World Bank in Washington, D.C., where she provided support to the World Bank Group's sanction boards in their adjudication of integrity compliance issues in the procurement and execution of World Bank finance projects. In 2019, she led a team constituted by the Rural Electrification Agency to support the Nigerian Electricity Regulatory Commission in fast-tracking the licensing of mid-grid developers under the Solar Hybrid Mini-Grid program of the Nigerian Electrification Project. Jumoke holds an LLB from the University of Lagos and an LLM in International Business and Economic Law with distinction from Georgetown University Law Center. She's licensed to practice law in Nigeria and the state of New York. Hi, Jumoke. I guess hearing your profile being read like that sometimes seems. Okay, so I'm just going to hand over to the chairman of the governing board of the ICLE, Mr. Tobe Nairoji, to give us his opening remarks.
Thank you very much, Nta, for what I would say so far, a job well done, anchoring these events. I just want to welcome everybody to today's session. I hope you all enjoyed yesterday's training. I thank Jumoke for taking the time to deal with what I think is a very serious topic, but then bringing so much life into it. I enjoyed it particularly myself. I hope that we all enjoy today's training. And then, yeah, we'll see how it goes. So thank you very much. And Jumoke, over to you.
Thank you very much, Tobe and Anita. Thank you for the opportunity once again to be part of this training. And thank you to all of you that are on this call now. And for those that were here yesterday, welcome back. And so let me share my slides now. Okay, so we're talking about the Petroleum Industry Bill 2020. And yesterday, we spent some time talking about why there is need for a reform, the journey that the PIB has taken over the past 12 years and the 8 years preceding that, when the whole policy drive was just beginning. We talked about the current challenges that we are facing, our oil and gas industry is facing locally as well as internationally, and what are the drivers, the key drivers for a successful petroleum industry. We also talked about the National Petroleum and Gas Policy that sets the tone for government's plan for repositioning the sector and moving away from the rent-seeking, export-oriented constructs that we have currently, and moving more into value addition in country and leveraging on our extensive gas resources to drive a gas-based industrialization. And after that introduction, we went into the PIB. I had said that it's a very wide document. It's a comprehensive framework that covers all aspects of upstream and downstream and midstream regulation, the fiscal regime, host communities, and it's not something that one can do justice to within the period that has been provided. So I chose to limit the discussions to governance and institutions as administration. We talked about the governance and institutional framework yesterday. The role of the minister, the role of the regulators. You recall that we mentioned that there will be that the PIB proposes 2 regulators, one for the upstream petroleum sector and another that will cover the midstream and downstream sectors. And we also talked about how they will be how the structure of those organizations, and whether we see elements of true independence, whether we see clarity and separation of roles, transparency, and all of those key levers that are required for an effective governance framework for the sector. And so today, we will be going into the administration section of the bill. You recall that yesterday we went through the key objectives of the PIB. And so for this discussion, I believe the relevant ones are the objective to promote transparency and good governance and accountability, the objective to create a strong regulatory framework, the objective to promote the efficient, effective, and sustainable development of the petroleum industry with emphasis on the frontier exploration and midstream development, and generally foster a conducive business environment for petroleum operations. And so, yeah, so we'll go into the administration now. Okay, so before we proceed, it's important that we understand the activities that are covered in these segments of the bill. So the administration is broadly divided into two parts: administration for upstream petroleum operations, for which the Nigerian Upstream Petroleum Regulatory Commission, I forget the full name, is responsible for. And then we have the midstream, downstream petroleum authority that regulates the midstream and downstream segments. So for the upstream, these are the activities that are covered, and it's clearly spelled out in the definition section of the PIB. It covers petroleum exploration operations, winning and obtaining of petroleum in Nigeria by or on behalf of a company, either on its own account for commercial purposes, all activities upstream of the measurement point related to the winning of petroleum. So the measurement point here is the point at which the petroleum is measured for royalty purposes. So the fiscalization point, if you may wish to use that term. It covers the construction and operation of gathering lines, manifolds for crude oil, natural gas, and water, high and low pressure separators. It covers the construction of and operation of facilities to treat crude oil and natural gas, flaring of natural gas, and compression and reinjection of gas into reservoirs. It covers the construction of facilities for producing electricity or heat from natural gas or other fuels as an energy source for winning petroleum. So they have to also create their energy sources. So it covers those activities. It covers the injection and reinjection of water into reservoirs, construction and operation of fixed and floating platforms or other vessels for winning petroleum, construction and operation of storage facilities, metering of well stream fluids, petroleum at the measurement points prior to transportation. It covers the sale and marketing of crude oil, natural gas, or condensate, or any of them at the measurement point, and all other activities which by regulations are considered to be upstream operation will be covered, as well as general administration and overhead. And there's also provision, because in some cases you would have facilities that sort of straddle between integrated facilities between the upstream and the midstream. And in those situations, the commissioner may consider the entire operation as upstream petroleum operations. Okay, so going into the key aspects of the administration of the upstream sector. Now, the challenge I faced in putting this slide together is that it's really wide. There's so much to cover. And I was trying to streamline the discussion as much as possible so that one just doesn't spend the whole day talking about upstream and downstream administration. So I'm just going to highlight key points of the framework. So one of the key introductions that the PIB will bring is the adoption of a national grid system for managing acreages. So basically, it's I found this picture online, and I believe it represents what a grid system looks like. So basically, it's having parcels, parcels that define clusters of unit parcels that define the license areas, and the parcels are expected to be 1 square kilometer each, and the commission will establish the numbering system for these parcels. And it's supposed to be used for the administration, for clear administration of upstream operations, defining the license areas, areas that will be relinquished, well locations, etc. And so I believe this is kind of like, I would liken this to the cadastral system that is used in the mining sector by the mining cadastral office, because in the same way, parcels are also are identified based on the grid system, and and each individual parcel is referred to as a cadastral unit. And I can't recall what the boundaries are, but it looks to me that that's a massive system, and it's a progressive system for managing mineral titles. So this is a laudable initiative. With respect to existing licenses and leases, the Act provides that boundaries of those existing the bill proposes that boundaries of those existing licenses that do not conform to the grid system will remain unaltered and be apportioned in parcel. Okay. So another key aspect of upstream administration is that it introduces a brand new licensing framework for the exploration and production of petroleum. So currently, as if you go back to the first session that we had, where Deidre Ibode took us through the legal and regulatory framework, and I outlined the types of leases and licenses that apply in the upstream petroleum sector. We had the oil exploration license, or we have, not we had, it's not past tense yet, the oil exploration license, the oil prospecting license, and the oil mining lease. And so in the PIB, it's proposing different nomenclatures. So one of them is the petroleum exploration license. The petroleum exploration license gives the holder the right to explore for petroleum on a speculative and non-exclusive basis. And the idea here is that these are exploration activities that are non-invasive. And so this license will be granted by the Commission. You recall yesterday that we mentioned that one of the minister's functions is to grant petroleum licenses and leases on the recommendation of the Commission. But in this instance, this particular license, because it doesn't really grant real rights to resources, is granted by the Commission without recourse to the minister. The term for the license is 3 years and is renewable for a further period of 3 years. And so basically this, my understanding of this is that basically the licensee here is just seeking to collect more data on particular areas. And so as regards that data, the Commission is to hold title, but the licensee is still able to grant data use licenses to third parties for a fee if the Commission approves. And if it's a PEL that covers frontier acreages, the PEL could permit the licensee to select one or more petroleum prospective licenses prior to the expiration of PPL. So we'll go into the petroleum prospecting licenses next. And this is one of the ways that the Act is seeking to promote frontier exploration. Okay, so the petroleum prospecting license, we can liken this to what we know as the oil prospecting license currently, is a license that entitles the holder to carry petroleum exploration operations on an exclusive basis. And it includes the right to drill exploration licenses, as well as a non-exclusive right to carry out petroleum operations within the license area. It includes the right to carry away and dispose of petroleum one during the drilling of exploration wells or production tests. And the term provided for the PPL is 6 years. As regards, so basically the term for a PPL depends on the terrain. So that's I believe that's a new introduction, having different terms applicable to different terrains. And for onshore and shallow water acreages, it's a term of 6 years, and it comprises of an initial 3-year term with an optional 3-year extension period. For deep offshore and frontier acreages, it's a period of 10 years, comprising an initial 5-year period plus a 5-year optional extension period. And the maximum size of the area that can be granted for an oil prospecting license also depends on the terrain. And for onshore and shallow waters, it's 350 square kilometers. Deep offshore fields is 1,200 square kilometers. For frontier acreages is 1,500 square kilometers. Now, this is very important because currently the size of oil prospecting license, I believe, is 1,000 square kilometers, or 5,000 for OEL and 1,000, I believe, for the oil prospecting license. And what I should have mentioned before going into it is that one of the main philosophy behind the administration of the upstream aspect is to ensure that acreages are managed efficiently. What we currently have is a situation where a lot of operators are holding on to large sizes of acreages and are producing or exploring in smaller pockets within the OML or OPL. and basically just leaving these other aspects if they don't consider it to be important enough to whatever, to basically not doing anything about the rest of the acreage till whenever they are ready to do that. And what happens is that there are limited acreages that can be given out in future bid rounds because a lot of it is being held up by operators that are not utilizing it. And so a key aspect of this bill is to manage these acreages more efficiently, such that if it's not used, it's dropped. So there's this drill and drop philosophy that runs through it. And also, it's also observed that as our parcel sizes are amongst one of the largest in the world, and so the idea is to have a significantly reduced size for PPLs going forward, and then we can have more players in the market and more efficiencies that will come with that. So the holder of an a petroleum prospecting license is expected to commit to a work program for drilling and on the field and exploration works. And this commitment is expected to be backed by a payment security issued by an acceptable bank. Such payment security could be a bank guarantee, a letter of credit, or a performance bond by a bank acceptable to the Commission. So the last one is the petroleum mining lease, so likened to the oil mining lease that we have currently. And it confers the right to search for, win, work, and carry away and dispose of crude oil, condensates, and natural gas. So the difference we have that the PIB is proposing is that for each commercial discovery of crude oil or natural gas, the holder can apply for a PPL. And so it's and the area that is granted, the holder can apply for a PML, and the area that is granted as a lease is limited to that commercial discovery. So you don't have extra parts of the acreage that you're reserving for future use. So pretty much one PML, apologies for that mistake, per discovery. And then where two or more PMLs are derived from a PPL and such PMLs constitute a single field, the PML will be considered as a single lease, even if their boundaries do not join. The duration of the PML is still 20 years, just like we currently have, and it includes the development period, and I'll talk about that shortly. Okay, so another interesting thing about the PIB is the provisions that it makes for awarding licenses. They're very detailed provisions as to the procedure that should be followed, and it specifically provides that all PPLs and PMLs are to be granted based on competitive bidding. There are very clear parameters for determining the winning bid. It could be based on the signature bonus, the profit all split, whatever parameters are listed there, or it could be a combination of these parameters, and the award will now be based on the point system, depending on the sort of bid that the bidders submit. And the Commission manages this bid process and is expected to issue guidelines for a bid process and stipulating basically what the terms are, the type of license that will be granted, and such bid guidelines will be accompanied by a model license or lease. The bid process is expected to be open to the public, which is interesting, and all conducted in the presence of the Ministry of representatives from the Ministry of Finance, the Ministry of Petroleum Resources, and the Nigerian Extractive Transparency Initiative, NATI. And I think that is a very important provision in the bill to ensure that there's transparency and accountability. And this is a theme that we see that the bill tries to achieve when we look at the provisions. So, like we mentioned yesterday, it's the minister that grants the PPL or the PML. So once the bid process is concluded, the Commission recommends the winning bidder to the minister for grant of the PPL or PML. And in terms of the signature bonus that is to be paid, it will be based on a transparent method that will be for evaluating the acreage. So it's not just a random figure or a situation where we don't know how these figures come about. The process for determining that signature bonus will be based on the transparent method. So that said, all well and good that licenses has been awarded based on competitive bidding. There's one exception that stood out, and that's in section 74.3, which states that notwithstanding these bidding parameters, where there is a bilateral or multilateral agreement between Nigeria and another country, the government may, for strategic purposes and in return for substantive benefits to the nation, direct the Commission to negotiate and award a petroleum prospecting license or petroleum mining lease to a qualified investor identified in the agreement or treaty. So this is where we push competitive bidding aside and look to the national interest, if the national interest, provided it is indeed in the national interest. There are concerns as to how this provision will be applied in practice, who determines whether it's strategic, what are the parameters for substantive benefits. So they're just concerns that this is a window for abuse. So it remains to be seen how this could be applied in practice. But to the extent that there are a lot of provisions that mandate transparency in the dealings with licenses and license holders and leaseholders and the documents and transactions they enter into, perhaps that might be a check for the power that is given to the minister in this section. So I mentioned that the commission is to develop model license and leases that will be attached to the grant of a PML or PPL. And you recall, I think it was the second session where Dr. Ayoni took you through petroleum industry contracts, the production sharing contract, profit sharing, rig service, concession, and all of that stuff. And so basically, the idea is that going forward, the commissioner could require the holder of the lease to comply with the model contract attached. So each lease or license will have a model contract attached to it. It could be a PSC where profit oil is allocated to the government, a profit sharing contract where cash equivalent of the profit oil is allocated to government, or it could be a risk service contract, or it could be a full concession. And that might require a joint venture or an unincorporated joint venture or an incorporated joint venture with the NNPC Limited that the bill is proposing for establishment. And so what I take away from this is that we would not have a situation where the OMLs are, for the most part, issued to the national oil company, and the national oil company now engages with the investor based on a production sharing or risk service or joint venture. These investors will get the assets in their own right and now have these contractual terms attached to it. And the contractual term could be any of the ones listed here, or it could be a hybrid or any other internationally recognized form of contract. Another interesting feature of the bill is that there are a number of things that are required to be disclosed publicly. The licensees or lessees are required to submit to the commission a summary of all the fees, taxes, profit oil shares, and other payments to government. They're required to submit the text of any existing contract, license, or lease or amendments to it with the NNPC 1 year after the effective date of that of such agreement. And if there's a default, there's an administrative penalty, a pretty steep one of $10,000 per day of default, and the text of any new license or lease or amendment thereto. And so for the summary of fees paid, existing contracts with the NOC, those documents are expected to be published on the website and available to the public. And I think this is one of the mechanisms that the bill is seeking to put in place to ensure that there's transparency and accountability in the sector. And it's quite laudable and impressive. Okay, so like I mentioned, the key part of this of the bill is the strategy to ensure that if parts of acreages that are not being used quickly go back into the basket and can be reawarded to other investors. And so this drill and drop strategy that runs through it. So petroleum lease mining leaseholders are required to initiate commercial production within the development period that is stipulated. Otherwise, the lease will be revoked on expiry of that development. So the development period is a period that is established in a relevant field development plan. So before, when the commercial discovery is declared, then the leaseholder or the license holder is required to submit a field development plan, basically a plan for the development of the field, to the commission for approval. Currently, the field development plan is submitted to DPR for approval, so it's that process continues. And that field development plan defines the development period. And so, but if there's no, if it's not defined, the default development period is 5 years for onshore leases and 7 years for other terrains, sorry. And so there's a requirement to initiate regular commercial production before the end of that development period. Otherwise, the license could be revoked, or will be revoked rather. And also, if the PML holder the PML rather ceases to produce in paying quantities for a period of 180 days, that lease may also be revoked by the commission. Force majeure events are excepted from this. And but there's allowance for a licensee to suspend production for more than 180 days if it has a shutting plan that it has submitted to the commission and it makes a commitment to restart production in accordance with that shutting plan. So there are also very strict provisions regarding relinquishment, also in a bid to ensure that acreages are managed efficiently. The bill requires mandatory relinquishment by PPL holder prior to the expiration of the initial term of 3 years or 5 years, depending on terrain, of every area that is not yet an appraisal area or a retention area. We'll come back to that, or a lease area, i.e. a PML area. So if after the initial term, you haven't identified areas where appraisal needs to be done, you haven't identified areas where retention applies, which I'll come back to, or a PML has not been issued in respect of that area, then you must relinquish it. And then there's also mandatory relinquishment after the commission, after the PPA holder informs the commission that a discovery is of no interest. So basically, the process is that while the PPL holder does its exploration, it gets to a point where it now applies to conduct an appraisal program. And after that appraisal program, it sees whether the commercial discovery can be declared, or whether the discovery is of no interest to that PPL holder. So once it informs the commission that the discovery is of no interest, then the commission would require the PPL holder to relinquish parcels that cover the structure of that commercial discovery. So you don't hold on to it to see whether sometime in the future it becomes commercial, maybe new technology comes in play, and then commerciality can be achieved. And also, where a PPA holder fails to submit its field development plan within 2 years of declaring a commercial discovery, the area containing that commercial discovery would also be relinquished. There's provision for voluntary relinquishments as well of parcels and sub-parcels, provided the licensee has complied with all obligations and the shape of the relinquished area is approved in order to maintain the shape of the acreage that is viable for awards in future rounds. Okay, so where a licensee has made a significant gas discovery, that licensee will be entitled to retain that area for a period determined by the commission, and such area shall not exceed 10 years. So that period is what is known as the retention period. So what is a significant gas discovery? A significant gas discovery is a discovery of substantial gas reserves that is potentially commercial, but cannot be declared commercial because there's no domestic market or an export market is yet to be identified. There's no infrastructural capacity, or maybe in situations where the joint development of additional resources is required to make it commercial. So this period of retention is basically that allows the licensee to seek to find the market or build commerciality around that significant gas discovery. So if at the end of the retention period, the licensee is not able to declare a commercial discovery in respect of that significant gas discovery, then the licensee has to relinquish that area. Okay, so as regards renewals, we also see this theme of drill or drop or using or leaving. If the field must continue, so this is renewal of PMLs, like a PML is granted for 20 years and it's renewable for further periods of 20 years as long as the conditions are met. And it's important, one of the conditions is that the field must continue to produce in paying quantities. And also, the Commission must be satisfied that the lessee has fulfilled its development obligations, payment obligations, and any other operational obligations, and is not in default of any obligation or lease condition. Renewal of PMLs will be on terms and conditions determined by the Commission, and a renewal bonus payable will be based on a percentage of the market value, presumably I believe is of the asset, though it's not clearly stated, on the renewal date in a manner prescribed by regulations. Okay, so back to relinquishment. I think my slides were a bit misplaced there. For petroleum mining leases, there's a mandatory relinquishment requirement after 10 years of any parcel that does not fall within the boundary of a producing field, and also of deep rights. So deep rights are formations that are deeper than the deepest producing field. So there's a mandatory relinquishment of these parcels and deep rights after 10 years. And of course, there's always the right to voluntary surrender for PPL and PML holders, provided the conditions are met. Okay, so an interesting thing about this petroleum industry bill is that licensees that currently hold existing OML and OPL holders have the option to voluntarily convert to a PPL or PML under the PIB. And so there's no mandatory conversion. And this is very important because the OML and OPLs were granted, and the holders made investments based on the terms of these lease. And so it would be, it's to change the terms in the middle of the game. It's could be basically government reneging on its obligation, and those are one of the contentions that has trailed the history of the bill as to whether there will be a forced migration into this new regime, into the new fiscals, and etc. So for voluntary conversion, the holder of the OPL or OML that chooses to convert must enter into a conversion contract. And the effect of such conversion is that they now stand to benefit from the fiscal incentives accorded to PPL and PML holders, which are being described as more incentivizing than what currently exists. But there's a catch. The conversion contract must contain a clause that stipulates that any outstanding arbitration claim and court case related to such OPL or OML be terminated, stipulating that stability provisions and guarantees granted by NNPC in respect of such OPL and OMLs be null and void, and also the incentives in Section 11 and 12 of the Petroleum Profits Tax Act would no longer apply. And those are incentives that relate to cost consolidation and also cost consolidation to incentivize the gas utilization infrastructure by upstream players. So the conversion contract, there's a window within which a conversion contract must be concluded, and it's at the earlier of 18 months after the enactment of the PIB or the expiration date of the OML or date of conversion of the, earlier of 18 months after the enactment or the expiration date of the OML or date of conversion of the OPL or OML. So for those that choose not to convert, the existing regime we have now continues to apply to those OPLs and OMLs until they expire. After the expiration, they now get converted to PMLs and PPLs as applicable. And upon conversion, whether it's through the voluntary conversion contract or is upon expiration, OML and OPL holders are required to relinquish 60% of the area, and they may select to hold either PMLs or PPLs for the remaining areas, depending on the level of work that has been done. Another interesting feature is that marginal fields that exist as of currently existing and producing marginal fields will be granted PMLs. So we will not have the concept of marginal field licenses going forward. There will be petroleum mining leases as well. And discoveries that are declared as marginal fields as of January 1, 2020 will be converted to a PPL. As regards assignments, mergers, transfers, and acquisitions, ministerial consent continues to be required for any interest in PPL or PML, and the Commission recommends the Minister grants consent. The Commission is empowered to grant consent in relation to PELs, as they're the sole authority that grant that title. The PIB now specifically states that change of control in a licensee or leasee shall be deemed to be an assignment. So that was not stated in legislation, or rather that is not stated currently in legislation. We have the case of Monipolo that I was it decided, or basically that holds that change of control. All right, I'm sorry, I'm getting it mixed up. And then we have the DPR guidelines that talked about the requirements for getting ministerial consent for assignments, and it also includes change of control. But there was also the question as to whether the guidelines could be law if it's not stipulated in legislation. And then when it comes to assignments for the purpose of creating security interest, only the approval of the Commission is required. That does not need to be escalated to the Minister. And so that is laudable because it will make transactions, financing transactions for upstream operations move quicker and with more certainty. And then the regulations that will prescribe fees, the regulations will be issued to prescribe fees payable by the applicant, and these fees will be based on the value of the transaction. Okay, so that's it with upstream regulation. We now move to the midstream and downstream regulation. Okay, so as we did before, we'll start with the activities covered under midstream petroleum operations. These are activities downstream of the measurement point of petroleum mining leases, construction and operation of lubricants, petrochemical and fertilizer plants, construction and operation of petroleum liquids transport pipelines, including pumping stations, acquisition, operation, leasing, and rental or chartering of barges, coastal or ocean-going tankers, construction and leasing and operation of tank farms and other storage facilities and export terminals for petroleum liquids, construction and operation of refineries, purchase and sale and trade and markets of petroleum liquids and other related and administrative activities. For midstream gas operations, I think I must have missed out a slide. Okay, so midstream gas operations, activities covered are activities downstream of the measurement point of a petroleum mining lease, whether or not related to the petroleum mining lease. So that's key. With respect to the construction and operation of natural gas transport or transmission pipelines, including the related compressor stations. It includes construction and operation of facilities to compress, transport, and deliver compressed natural gas, construction and operation of gas processing facilities and central processing facilities, construction and operation of storage facilities for storage of natural gas, construction and operation of gas to liquids plants, lubricants and petrochemical and fertilizer plants. So we also see that as midstream petroleum operations. So it's repeated here. It includes LNG plants and related terminals, as well as storage and transport of LNG, and generally the purchase, trade, sale, trading, and marketing of natural gas with respect to sale to wholesale customers and distributors. For the downstream gas operations simply means all activities entered into for the purpose of distribution and supply of natural gas to retail customers. And with petroleum products as well, it covers the distribution and supply of petroleum products to retail customers. Okay. So the licensing, the PIB introduces a licensing framework for the downstream gas and downstream petroleum liquids. And so I'll just go through each of these licenses quickly. And the first one is the gas processing license. And this covers the installation and operation of gas conditioning plants, gas processing plants, GTL plants, LNG plants, ethane extraction plants for account of the owner or for open access to customers. So this could be merchant or tolling plants. A merchant plant is one where you're operating for your own account. A tolling plant is one where third parties are utilizing for a fee. The bulk storage license allows the licensee to undertake the bulk storage of natural gas, either for its own account or on behalf of customers, as stipulated in the license. We have the gas transportation pipeline license, which gives the holder the exclusive right to own, construct, operate, and maintain a gas transportation pipeline within a route as defined in the license for its own account or for third-party access as a common carrier, as stipulated in the license. There's the gas transportation network operator license, which confers the holder the right to convey natural gas through a gas transportation network and provide access to shippers based on the gas network code, balance inputs and outputs, and charge based on approved tariffs. We have the wholesale gas supply license, which is confers the right to purchase gas directly from any lessee or third party and sell and deliver wholesale gas to wholesale customers and gas distributors at any location in Nigeria. A qualified person or a qualified applicant for a wholesale gas supply license is the lessee producing natural gas. And a lessee producing natural gas is qualified to apply for a wholesale gas supply license and shall be entitled to be issued that license from the authority. And then we now have the retail gas supply license, and this confers the right to sell or retail marketable natural gas to customers, the right to establish and construct and operate facilities to deliver CNG and small scale facilities for LNG, so mini LNG plants that do not require a processing license, or for transportation by truck, rail car, or marine vessels to customers in compressed or liquid form, including customers using LNG as marine bunker fuel. So that's what the retail gas supply license entitles a holder to do. There's the gas distribution license, which allows the holder to establish, construct, and operate a gas distribution system and to distribute and sell its natural gas to customers in a local distribution zone without discrimination. Um, so this this is very keen. I mean, all of the licenses are novel and interesting development, but the gas distribution license in particular, because currently what we have is NGC for the most part franchising um, operators, giving them the right to develop gas distribution networks on their own behalf, as though they were the only entity allowed to own and operate gas distribution licenses in the country. So this clarifies that aspect of the value chain, that any operator can apply for this and be issued a gas distribution license to own, establish, construct, and operate one within the local distribution zone. So there's also the domestic gas aggregation license. And this license is issued to an entity. So that will be the Gas Aggregation Company of Nigeria, presumably, to support the implementation of the domestic gas delivery obligations imposed on gas producers and other related functions. So the domestic gas aggregation license will be granted for 2 years and renewable for durations of 2 years each until the attainment of liquidity in the gas sector, after which gas aggregation will cease and the license will be terminated. And so here are all the licenses that the PIB proposes. There's also, there'll be a category of customers termed wholesale customers, wholesale gas customers. And basically, they'll be entitled to secure marketable natural gas from any wholesale gas supplier or a lessee. So the authority, and I believe I've been saying commission all this while, for the midstream and downstream segment, the authority is the regulator. So the authority is empowered to issue regulations specifying the customer or classes of customers that qualify, that will be eligible to be regarded as wholesale customers. And it would also specify the qualifying criteria for this. Okay. So for petroleum liquids, the PIB also introduces different license types. There's the crude oil refining license, which allows the holder to procure, construct, and install and operate facilities to process crude oil on its own account into the different components that we have, the POS, AGO, PMS, AGO, and etc. And to sell such chemicals and petroleum products at the exit of the refinery. So um, construct and own the facility as well as sell the product. There's the bulk petroleum liquid storage license, which allows the holder to undertake the bulk storage of petroleum liquids, whether for their own account or for on behalf of customers. We have the petroleum liquids transportation license, which just similar to the gas transportation license, confers the holder with the exclusive right to own, operate, and maintain transportation pipelines for the bulk transportation of petroleum liquids within the routes defined in the license, either for its own account or as a common carrier, providing third-party access as stipulated in the license. We have a petroleum liquids transportation network code, network operator license, which would authorize the holder to convey transportation liquids through the a transportation network, undertake balancing and inputs from the network, provide open access to transportation network, and charge for the use of the transportation network, basically operating within the context of a network code. So the bill stipulates that the authority will grant only one petroleum liquids transportation network license for a specified or geographically defined area. And the authority may also, at its discretion, issue licenses to other parties for the operation of isolated or dedicated pipelines. We have the wholesale petroleum liquid supply license, which confers, authorizes the supplier to sell and deliver petroleum liquids to bulk customers in Nigeria and also for export. A qualified person for this license is a lessee producing crude oil or condensate and a crude oil refiner, and it shall be issued, and such licensees and crude oil refiners shall be entitled to apply for and be issued a wholesale petroleum liquid supply license going forward. So to export petroleum, producers that are exporting petroleum will need to apply for a wholesale petroleum liquid supply license. There's also the license for distribution of petroleum products, and this allows a holder to develop and maintain safe, efficient, and reliable economic service for the distribution of petroleum products to individual customers and petroleum product retailers. We have the petroleum products retail license, which allows the holder to construct and operate facilities for the retail sale of petroleum products. So these are fuel stations. And lastly, there's the petroleum production license that allows the holder to establish, construct, and operate facilities for the production of petrochemicals and to sell the petrochemicals so provided. Well, I feel like taking a deep breath after this. So now we've looked at the different license types for both the for gas midstream and downstream, and petroleum liquids midstream and downstream. Um, as regards license administration, the authority is empowered to grant, renew, and modify or extend these licenses. So there's no recourse to the minister for the most part. But however, when it comes to the establishment of refineries, then the authority acts based on the recommendation from the minister. Um, The licensing process requires the mandatory publication of license applications, and and also giving interested parties the opportunity to comment and make representations. The duration of licenses are not yet specified; they will be specified in regulations. The assignments and transfers of these licenses and leases are subject to the consent of the authority. I do not see anything that specifically says that the change of control in the licensee would require consent. So we'll wait to see if not more is said, or whether as the bill develops, that will be included. And the bill also contains clear grounds for and the procedure for revocation of these licenses. And this ground includes failure to commence activity within a times period to be specified in the license, in the regulation, sorry. So also the bill specifies the conditions that must be in place in order for the authority to grant a license. The applicant for the license must meet all required technical standards. The location of the facility and the rights of way associated must be acceptable to the authority. Of course, it must meet HSE standards. It must provide for the efficient and economic use of facilities and pipelines. So kind of like a just and reasonable or prudent practices. Does not involve excessive capital expenditure or operating expenditure. Um, the includes an acceptable environmental management plan or decommissioning plan and provides for a decommissioning fund. It provides for the elimination of routine gas flaring and also includes a detailed program for recruiting and training Nigerians, scholarship schemes, internships, and all aspects of professional development for Nigerians and capacity building for Nigerians. Okay, so going into the economic regulation aspect of um, the bill provides for third-party access to infrastructure, pipelines, storage facilities, and the likes. So basically, gas transition pipeline and networks, um, open access must be granted to persons that require the transportation of gas, marketable gas, to points of consumption, sorry. And open access must also be granted with respect to facilities used in midstream petroleum operations to persons that are licensed to supply petroleum liquids, and as well to and crude oil refiners. Open access is required for in respect of harbors, jetties, storage facilities, and transportation facilities. With respect to gas, the existing network code is adopted for the gas transition network, and this network code, Nigerian Gas Transportation Network Code, sets out the standard terms and conditions for connection to, interconnection with, and access and use of the gas transportation network. The authority is empowered to develop separate terms of access for transportation pipelines that are isolated, and it may also develop special terms of access to gas distribution networks. And with respect to petroleum liquids, the authority is required to develop a network code for that segment, for if transmission networks in respect to petroleum liquids. Okay, tariff methodology is another big area. The bill empowers the authority to design a pricing framework for transportation, distribution, and processing of petroleum. And this facilities relating to transportation, distribution, and processing. So this is not the actual product price. And such pricing principles must be cost reflective, or rather, in designing this pricing framework, the authority is to be guided by some specified pricing principles, that tariffs must be cost reflective, that it must permit a reasonable return on investment, that tariffs must not discriminate between customers or with similar characteristics, and also that tariffs be determined in USD or other foreign currency in order to attract investment into the sector. But notwithstanding, payments could still be made in Naira at the CBN rate. With respect to new gas transportation pipelines and distribution networks, there's some additional components that we included in tariff methodology to incentivize investments in this new infrastructure. Prior to establishing the new tariff methodology, the authority rather, is expected to conduct stakeholder consultation and take on board the comments that that is derived from this process. One key area that is of concern as regards pricing is in relation to gas. So the PIB proposes a fixed base price for gas um, at $3.20 per million BTU with an escalator until 2037. And what is problematic about this, and it's really interesting that the price is actually specified in legislation, is that um, basically it's price fixing, and it will not promote competitiveness in gas supply. And as you know, as we talked about the national gas policy yesterday, there's the vision to transition the sector into a competitive wholesale gas supply market. And for this, it's imperative that the pricing be based on the willing seller and willing buyer basis. But when you have the pricing fixed in legislation up until what I'll call the foreseeable future, then that negates this goal, and it's a strong disincentive to investment. So that's one area of concern that I thought to highlight. As regards product pricing, we also see that the authority has the powers to regulate prices charged by licensees. And in the exercise of this power, it's to be guided by several principles outlined on this slide. But what's curious about this is that the products market has already been deregulated. So it's what's interesting to also see that the authority is given powers to regulate product prices. Okay, so competition and market regulation is another aspect that the bill provides for, and it's very important to develop competitive markets in order to drive efficiency, remove barriers to entry. When barriers to entry is removed, there are more players, and that promotes efficiency, drives down prices, and competition is just the benefit of everybody. And so the authority is has the power to monitor the state of the markets, regulated in terms of competition, arrest situations of abuse of dominant powers, um, assess whether the market is operating efficiently, and remove and address and basically assess arrangements that could constitute barriers to market entry, determine whether there's any anti-competitive activity being carried out, and the likes. And in exercising this responsibility, it is subject to the Federal Competition and Consumer Protection Act. So it's not very clear how this is supposed to play out, because we have this general competition regulation that applies across sectors. And is it the case that the um, midstream and downstream segments will be governed under the rules applicable generally, or is it the case that the the competition regulation will be sector specific? It's not very clear, and there's a strong likelihood for an overlap here and uncertainty here, which uncertainty basically is a disincentive for investment. Okay, we're almost getting to an end now. Um, One of the key things that the bill establishes in terms of ensuring that environmental footprint is minimized, as espoused in the petroleum policy, is the creation of an environmental remediation fund. So lessees and licensees are required to pay a prescribed financial contribution into an environmental remediation fund that will be established by the commission or the authority, depending on the segment. And these funds are supposed to be used for the rehabilitation or the management of the negative environmental impacts with respect to the license or the lessee. Um, in determining the amount of contribution, the commission or the authority must take into consideration the size of the operation and the level of environmental risk that may exist. And to ensure transparency, the financial contribution to the fund will be subject to audit by the licensee or lessee in accordance with guidelines that the authority or the commission may issue. So wherever you find that the licensee or lessee fails to rehabilitate or manage or is unable to undertake rehabilitation or management of the negative impact of its operations on the environment, the commission or the authority may apply the fund to undertake such rehabilitation that is required. Um, Lastly, well, not lastly, but the last thing I'll highlight is the provision for the requirement for a decommission and abandonment fund that the PIB proposes. So this is a mandatory requirement on all licensees and lessees across upstream, midstream, and downstream segments to establish a decommissioning fund in a financial institution that is not affiliated with the license or lessee. And such fund is to be applied strictly towards decommissioning and abandonment costs. The commission authority is empowered to access the fund and engage third parties to perform those decommissioning or abandonment activities if the licensee or lessee fails to do so. So as part of the licensing requirements, an applicant is required to submit a decommission and abandonment plan. And this plan will establish the yearly contribution into the fund based on its reasonable estimate of the cost of decommission abandonment in a manner provided in regulation. And the yearly contribution to the fund will be reviewed every 10 years. It's interesting to note that contributions into the fund are eligible for cost recovery and are tax deductible. And after the fund has been applied towards decommissioning and abandonment, any amounts remaining will be considered income for the licensee or lessee for the purposes of production sharing or tax purposes. So that's okay. So one more item that I thought to highlight is this concept of deemed approval. So I believe this is one of the strategies to ensure that the regulatory agencies function efficiently and in a timely manner. So, across the provisions of the law, you see timelines provided for certain approvals to be granted. And where no response is provided within the timeline by the approving authority, then such approvals are deemed to be granted. So, we see this in relation to PPLs and PMLs, where the Commission has made a recommendation as to the grant of a PPL and PML, and the Minister fails to inform the Commission of its decision within 90 days. We also see this respect to assignment of and transfer of a license, a PPL, a PML. Such consent, the minister's consent is deemed to be granted within 60 days of a recommendation by the commission if the minister fails to provide a response. Um, as regards the commission, there's also deemed approval where a licensee, a PPL holder, makes an application, submits its approval program, its appraisal program, and such program is not approved within 60 days of the submission, then it's deemed approved by the commission. And then also the field development plan, if it's not approved, there's no response within 180 days from submission, then it's also deemed approved by the commission. With respect to the authority, if the authority, as regards assignments and transfers of licenses, if the authority does not respond within the period that is stipulated in regulations to be issued, then such consent is deemed to be approved. So that's an interesting concept. This is now beyond the executive order. It's actually prescribed in legislation, and it will be interesting to see how this plays out. There are provisions for deemed approvals, I understand, in mining legislation, but I'm not sure it's being applied the way it was designed. So it remains to be seen how this would actually work in practice. So this is my last slide. In conclusion, I'm taking us back to the key features of legislative framework as outlined in the petroleum policy. And so basically the question to just throw to everyone is when you're looking at this bill, evaluate to the extent to which the PIB delivers on all of these fronts as it relates to the administration of the petroleum industry, in particular, accountability, transparency, international best practices, stakeholder engagement, emphasis of gas as a fuel in its rights. We see that clearly. Greater focus on midstream and downstream segments, which we see very clearly, and a clear strategy for long-term sustainable development, which I think is also very apparent in the bill. Thank you very much.
Thank you, Jumoke. This was very interesting. I'm going to just shoot straight into the questions because it's just both of us here. So first of all, I would say that all the slides, we want to finish, the whole 16 days and then send out the slides so that it's done in an orderly manner, which is why I'm asking everyone to please be patient. We will send out the slides to everyone, posting their email addresses. All right, so I'll just go straight to the questions. Ugochukwu is asking, what is the practicability of enforcing non-compliance within the specified development period? The provision is akin to what we have in C of O's for landed properties. Majority of the C of O have terms like building must be commenced with a 2-year period, else the C of O will be revoked. Till date, I cannot attest to where this condition has been enforced. Retaining this condition, in my opinion, is authorized as in recent times. It has proved not to be effective nor efficient. My question then is, if the presenter agrees with this, where in the affirmative are there recommendations to obviate this identified lapse?
That's a very interesting question and a very interesting observation. Well, at the end of the day, we have regulations being implemented by human actors. The important thing is that the regulation is there. And so you see situations also when you look at development of landed property, there's requirement to develop within a specified period, and people don't necessarily adhere to that, and it's not enforced. But the day they choose to enforce it, right, there's the right to enforce it. At least that power is there. And one can only hope that the actors that are put in these regulatory institutions exercise the powers that are given to them in a manner that will be beneficial to everyone.
Okay, so the second, Kechi is asking, is there a yardstick for determining what amounts to national interest, or national interest in what the government says it is, what the government says it is?
I think that's precisely the problem. There's no yardstick for determining what is in the national interest. I guess it's one of those things that if you see it, you should know it, but there's no yardstick. So that's where the problem is. And I'm not sure if you can actually really have a yardstick per se, but what's more important is that there's a check on this ability to grant licenses based on the national interest. We see there that it says, one, there must be bilateral and multilateral agreement. So that has to be there. So you cannot grant it to your friend in the national interest. You have to have signed a treaty. So I think that that's a high level of responsibility, and possibly one can consider that as a check. But it's one of those areas that could be somewhat gray. National interest could be many things, depending on where we are in the spectrum of things.
Okay, so Ade Dolapo is asking, measures, assignments, transfers, and acquisition. What is the stipulated time frame that the minister grants consent? In event where the minister fails to grant consent within the stated time frame, can it be deemed as no consent is given?
I think I mentioned that the stipulated time frame is 90 days. 90 days, I'm looking for it right now, to grant consent. And yes, the bill provides that if consent is not granted, let me just check that for you. It's on the slide, but I forget things quickly. If consent is not granted within that stipulated period, then the license is deemed to be the consent is deemed to be granted. That's what it says. Whether you can take that to the bank is a different question, but that's what the law says.
Okay, so Sandra really asked, the question is really long, but I think the gist of it is, does the PIB allow third parties of subsidiary companies to go ahead and directly seek the consent of the minister to transfer its PPI or PML? So she created a scenario first, and it had to do with third parties. So the question is, does the PIB allow third parties or subsidiary companies?
Okay, so I'll have to look at the provision closely to see if that's the case, but I don't see that. I mean, you sell something you own to somebody, and you as the owner need to go and tell your landlord, maybe you sublet, and you go and tell your landlord that you need him to consent to the sublease. I don't see a situation where the person you sublease to goes to the landlord and now starts reporting that, oh, your tenant sold me something. It doesn't sound, process-wise, it doesn't sound right. So I don't know. I would have to check to see if there's a specific, if it specifically allows that. Maybe we'll see that in regulations. But yeah, that's
I
my
think
response.
the last question. So Vivian is asking, I believe the OEL is no longer in use. Will the PEL, which is meant to replace the OEL, resurrect the use of exploration license in the Nigerian petroleum industry?
Okay, yeah. So yes, you're right. I also believe it's no longer in use, but I think what I think the strategy of the PAL is trying to achieve is to promote exploration in frontier areas. Those are areas that have not been not significant exploration has not yet happened, and this sort of exploration is exploration that is not invasive. You're not drilling, more like surveying and using non-invasive techniques. So I think that the strategy is to promote this sort of licenses to encourage people to go into frontier basins to explore.
Okay, that's actually the last question in the Q&A box. So I guess we can round up. Jumoke, do you have any closing remarks? And like I said, please, all the slides are going to be sent out at the end of the 16-day session, so that we do it in a very orderly manner. So please be patient. We're going to send out the slides to everyone. So, Jumoke, any parting words before we close the session?
Okay. Well, I'd like to thank everyone that's been in here, that has been on this Zoom call, 317 now. Thank you for your time and your attention, for the questions, for the chat, and those that were also here yesterday as well. It's been interesting sharing thoughts, going through this PIB with everyone here, and also thanks to the organizers of this energy training webinars. And it's been a pleasure.
Okay, so our next session is going to be on the 7th and 8th. So 7th is next week, Wednesday. So we're going to have the next session, and then also on Wednesday on this 16-day session of energy for, foundation course for lawyers. So thank you, everyone. It's been nice spending time with you all. Like I said, the slides will be available at the end of the 16-day session. Bye.